Good afternoon, guys. Thank you for being here. We are on topic 4. Before we continue, I have to thank one of the students, Tess, for highlighting to me that I may have potentially confused all of you in relation to pre-registration contract, in relation to one subsection that I may have misquoted. And what I want to do is that I want to just run through that with all of you, and also for the benefit of the online students, so that we are all on the same page in relation to that. Okay? Now, when we look at pre-registration contract, we know under the common law, if you looked at Kellner and Baxter, where they found the promoter personally liable, and Black and Smallwood, because the party to the contract did not think that they were signing it as being personally liable. In that case, they were not found liable. So there was uncertainty under the common law. To overcome this uncertainty, Section 131 of the Corporations Act was introduced. Now, if you look at Section 131 sub 1, it says company is formed and company ratifies the contract. In that case, company is liable. Section 131 sub 2, where company is not formed or company is formed but does not ratify the contract, then the person who enters into the contract becomes liable. Now, 131 sub 3, if an action is brought due to subsection 2, where the company is registered and it does not ratify the contract or enters into a substitute, the court can order the company to any of the following remedies, all right? Either order the company to pay all or part of the damages that the person is liable to pay, transfer the property if received through the contract back, or pay an amount to the party to the contract. So these are the remedies that can be obtained where the company has been registered but does not ratify the contract. Now, I think I must have misquoted Section 131 sub 4, where company ratifies the contract but fails to perform the contract, all right, or fails to make payment. Now, in such a case, the court may order the person to pay all or part of the damages that the company is ordered to pay. All right, so in this case, where the company is formed, it ratifies the contract, but it doesn't want to continue with the performance of the contract. In such a case, the court may order the person who entered into the contract to be liable. Okay, are we on the same page? Okay, I appreciate feedback, so just in case, sometimes my mind works faster than my speech ability, and sometimes I'm human, I make errors, so please come back to me so that we can rectify it. Okay? Thank you. Next, for today's topic, let's look at what we are doing. You have to understand how a company is managed and the division of powers between the board of directors and members in a general meeting. Then you have to look at the role of members and how members' meetings are convened and conducted. And then you have to know the different types of directors and officers, company secretary and the appointments. And last but not least, understand how a director's board meeting operates. So basically, we are looking at the organs of the company. The organs of the company is divided into two. One, board of directors, because we know a company is a legal myth, doesn't have an existence, so we need this brains, hands, and legs. And for us to know who the brains, hands, and legs are, we have got the board of directors. And we have got members in the general meeting who would then run this company together. However, the management decision of a company rests with the board of directors. So this is what we're going to look at. Who has what type of powers, and can each of these organs usurp the other's powers? And where do you find these powers is what we're going to look at in essence. Now, from this topic onwards, you will be assessed in your multiple choice question, topics 1 to 8, and from here onwards, it will already be part of your exam. You can be examined from topic 4, I don't know, but it may be part of it. And if you are, these are few of the areas that you can look at. One is division of powers between members and directors as a potential. The other is members' meetings. How can it be convened? It can be a short answer question with 10 marks. All right, it's been asked before. So although it's relatively procedural, but it is important. Now, company as a separate legal entity, it is artificial, it needs people to manage it, and that's why we need organs of the company. And in this case, as I told you, we look at the board of directors as well as members in a general meeting. Now, we have different types of decisions. These are the 3 types of decisions that normally is taken in a company. One is an enterprise decision, the other is capital decision, and constitutional decision. What are enterprise decisions? What does enterprise means? Business decisions. So business decisions of a company should be taken by? Who should take the business decision of the company? Directors or members? Members or directors? Directors, because directors direct the company. So they should be making business decisions. What are the type of business decisions that you can think of? Whether or not we should start a new plant, whether or not we should buy more stock, these type of questions will be answered by the director. Next, we look at capital decisions. What are capital decisions? Your funding requirements. Do you take another bank loan? Or do you issue more shares? How are you going to finance a project? These are called capital decisions, all right? And this too will be made by the directors. Now, when we talk about constitutional decisions, what tantamounts to constitutional decisions? Decision to amend the Constitution. Whose right is that? Members. That's right. So we are here, by looking at the types or categories of decisions, we have already separated as to who would have what decision. All right? So we have said that in terms of enterprise decisions and capital decisions, that would belong to the directors. As for constitutional decisions, it would be with members. Now, these is some of the powers, division of powers. Now, if we look at powers of board of directors, generally under the replaceable rule, section 198A, the powers are vested with the board of directors to manage the company. Now, if the company has its own constitution where it states the powers that is given to the board of directors, then the board of directors would follow that. However, if the company does not have its own constitution, it adopts the replaceable rule, then replaceable rule 198A tells us that the powers are generally vested with the board of directors. Okay? And under that, they can issue shares, debentures, borrow, they can do everything. What is execute negotiable instrument? What is negotiable instrument? Can you give me an example of negotiable instrument? No? A check is a negotiable instrument, all right? A letter of credit would be a negotiable instrument. So these are called negotiable instruments. And of course, the power of the board is to convene general meeting under section 249C and to determine the dividend payable to the members, section 254U. Now, when you look at the powers of members in general meeting, you look at that they can appoint directors, they can also remove directors, but there is a difference between sections 203C and 203D. In relation to 203C, this is a proprietary company. If they adopt the replaceable rules, they will rely on this section, which tells that the members have a right to remove the directors. However, because it is a replaceable rule, you can actually replace it and say, members do not have rights to remove the directors. Or you can say, this director is to be on the board forever until he dies. You can say that. It'd still be valid for a proprietary company. But Section 203D is not a replaceable rule. It is a section in the Corporations Act. And this is applicable to a public company. In a public company, if you have a constitution which says John is to be appointed as a director of XYZ Limited for the rest of his life, and a member wants to remove him, can the member do so? Yes, the member can do so because that section provides, notwithstanding whatever said on the Constitution or any agreements that may have been entered into with that director, a member can still remove the directors. All right? It is quite different from the replaceable rule of 203C because this can be removed and can be changed for a proprietary company, but it cannot be removed. The power cannot be removed for a public company. All right? Then you have got Section 202A, remunerate directors. Isn't it interesting? On one end, you can see directors actually decide on dividends for the members, and on the other side, you see members actually deciding on how much the directors are going to be paid. All right? So they both are quite evened up. All right? Next, you look at Section 249EF. How can a member call for a meeting? Maybe you want to put an asterisk there, and when you're preparing a cheat sheet for the final exams, you may want to put all those in there, because if you get a short answer question, you do not want to be shortchanged. All right? So these type of questions have been asked before. And 249N, members' resolution. And Section 136 talks about creation and alteration of a constitution. Chapter 2E talks about related party transaction, where a director has got a transaction with a related party who is defined under Section 228, who could be a spouse or a mother or a father or something like that, and there will be some financial gains that can be received by this director by virtue of Section 229, then they have to make a disclosure. And this disclosure must be approved by the members in a general meeting. All right? And this is particularly applicable only for a public company. It's not applicable to a proprietary company. Next, we look at Section 327B, appointing and removing public company auditors. 246B to D, variation of class rights. All this we'll be seeing it later, or we'll be dealing with it at a later time. And also approving capital reduction and buybacks. Now, Section 198 tells that the broad management powers are vested with the directors. The general rule is that these powers are conferred on the board of directors to make management decisions, and members cannot interfere with this right. Okay, they cannot tell directors, look, go and buy shares there, go and start a business here, sell the property of the company. They can't do all that. They are not empowered to do that. All right? If the most that they can do when they're unhappy with the director, what can they do? Remove the director. Change the constitution. These are some of the things that they can do because it's within their constitutional right. I'm not happy with you as a director. I now pass a resolution and remove you and appoint directors who would follow my direction. Or I will change the constitution, I'll modify it to say any transaction that's more than $5,000, you have to come to the members' meeting and get approval. These are some of the limits that I can place on the unfettered powers of the directors. All right? Now, please remember the director's motivations and duties lies in the best interest of the company. Whereas, when you're talking about the member, his or her motivation and interest is for self. They are not responsible for the company. They decide for their own benefit. So there is a lot of difference. When the company decisions are left with the member will try to make decisions which are beneficial to them. Whereas when a director makes a decision, they have to make sure that the decision is in the best interest of the company. Otherwise, they will be in breach of directors' duties. All right, and directors' duties are contained from section 179, 180, 181, 182, 183, and criminal equivalent, section 184. Now let's look at the case of Automatic Self-Cleansing Syndicate and Cunningham. What happened in this case was that one of the shareholders decided that the asset of the company must be sold. So he convenes a meeting and passes this resolution that the company asset be sold. And when the directors refused to do so, and Mr. Cunningham is one of the directors, he decided to bring an action saying that the directors have not followed the resolution that the company must sell the assets to a nominated company. Now, the question before the court was that, did the members have that power to pass a resolution directing the directors to sell the property or asset of the company to another person? No? Yes? What do you think? Do members have the power? No, they don't. Because in that case, what happened was that the Constitution said the power to manage the business of the company vested with the directors, and also the decision to whether or not to sell the property vested with the directors. So in this case, the directors had the rights and not the members. The Constitution didn't allow the members to give directives to the directors. All right, so in this case, the court said, look, members cannot usurp the obligations or the powers of directors. All right, so this case is quite clear in that regard. Next case is John Shaw Salford Limited and Shaw. This is actually a family business. There was 3 directors who were also shareholders. 2 of them owed the company some money. All right, because they owed the company money, they agreed to resign and also agreed to pay back. And when the company made a request to ask them to pay back, they were unhappy and they refused to pay. So the company then started a legal action against both of them to get the money back. Now, they are also major shareholders, remember, all right? They've resigned as directors, but they're still major shareholders. 3 shareholders, 2 of them are majority. So they then convene a meeting saying that the company shouldn't bring a legal action against them. And they pass the resolution. All right? Now, the question before the court is, must the company discontinue the litigation against these 2 shareholders? The power to initiate legal action is with whom? Is with the company, and that means the board of directors would decide. Correct? And in this case, the court said, look, you cannot go to the company and pass a resolution directing the company not to sue, because that is not within your powers. Are we good? Silence means? Hello? I think I can even hear the chairs talk to me now. Okay. And in NRMA and Parker, it was about how will a vote be taken. Was it through poll and or through poll? Okay. Now the decision of how a vote should be taken again vested with the directors and not the members. So the members didn't have the powers to actually direct the directors on the manner in which votes will be taken in a meeting. So you have now 3 cases telling you clearly that members do not have the powers to manage a company because those powers are vested with the directors. And if you have a question on division of powers between members and board of directors, you have to remember that management powers generally are with directors, provided that they adopt the replaceable rule. And it depends on the facts of your question. And most of the time, you will be tested where they are adopting the replaceable rule by default. So you'd start off with section 198A and tell that the powers vest with the directors. And if the members try to usurp these rights, then the directors do not have to follow those decisions simply because these case laws tell us that. You can quote Cunningham, Salford's case, and NRMA and Parker. You may ask me, do I have to do all three? No, you can choose one of those cases to support your point. All right? And if the question further asks you, what can the member do? Then you tell them the member can replace the directors. All right? Remove them and replace them with another director who'd follow their direction, and also amend the Constitution, if so desired. Right. Now, members can remove. We have already looked at Section 203C and 203D, or restrict their management powers by virtue of Section 136. If the board is unable to act due to a deadlock, most of the time a board of directors will have uneven number. We don't have even number, because if you have an even number, you'll have deadlock, where 4 agrees, 4 disagrees. It will be difficult. But for some reason, even if you had an uneven number, for some reason, some director don't turn up, and then you have a deadlock. Now, in such cases, there are some residual powers with the members where they are able to exercise to break the deadlock. But these residual powers are exercised very rarely. In most circumstances, they actually encourage the appointment of another director to resolve this deadlock. All right? But still, the law recognizes that members do have this residual power. And this was decided in the case of Massey and Wales, that members should appoint new directors to resolve deadlock at board level instead of exercising reserve powers. The reasoning is that directors would have to act in the best interest of the company, whereas members will act in the best, on their self-best interests. All right? They will look after themselves. They don't really technically care much about the company, because you want profits to come to you, all right, in terms of bigger dividends. So you will decide according to what is best for you as a member. All right, with that, we are done with division of powers. We looked at Section 198A. We said general powers are with the board of directors. We looked at cases where the members tried to assert these powers, and we looked that the courts were reluctant to allow the members to assert their powers. And they said, no, you can't do that because these are management decisions and it has nothing to do with constitutional rights, and you can't do it, full stop. Now, the only remedy that members have is that remove these directors, appoint new directors, or amend the Constitution. All right, with that, we are done with division of powers. Now we're moving to members' meeting. Okay. Where I come from, I mean, I used to do company secretarial work many years ago, and when we have an annual general meeting, it means happy times. It means grand hotels, good dinners or lunches, goodie bags, and a lot of stuff to please the shareholders so that when they're full, they're content, they'll just approve all the resolutions. All right? And this is what happens, and we call it an annual great meal. All right? AGM. So it becomes an annual great meal. You just come and have a feasty meal, and that's it. You approve anything. And most of the time, most shareholders are retired. They just come there and sit and have fun and vote whatever you want them to vote on. All right? So a members' meeting is called a general meeting, and it will be held once a year. And Section 250 and Sub 1 and 2, all public companies must hold AGM within 18 months of registration and then 5 months of end of financial year. So if your financial year ends on the 31st of December, by which time must you have an annual general meeting? By May, that's right, because your audited accounts will be valid for 5 months thereafter. Okay? Now, section 2540N sub 4, it is not required for one-member public company. And it's not required for proprietary company. It's quite obvious. If you have just one member, what are you going to do? Call for yourself for the meeting and approve everything? It's not logical, right? So all other members' meetings are called general meetings. Now, it used to be called as extraordinary general meeting, right? Annual general meeting is every year, you table the audited accounts, and then you do some normal stuff that you do within an annual general meeting. But suddenly, after you've got all the approvals that you need for the year, and as you're moving throughout the course of the year, and you realize that you need more money for investment in a certain project, and the approval that was given in the general meeting was only up to 1 million. Now you need 2 million. Then you convene another general meeting to get the approval for that extra 1 million, for an instance. So that's called an extraordinary general meeting. It's not the general one, but it's a general one, but not like the general annual general meeting. It's something that's arisen for a purpose. Okay? So these are the usual business of the annual great meal. Okay? One, you give the consideration of annual financial statements, directors and auditors reports as required by section 317, elect and remunerate directors. At this meeting, you will decide what is the remuneration for each of the directors. You will appoint and remunerate auditors. That will be question time to the management and the auditor. So the members are allowed to question the management and auditor, and other resolutions can be requested at the AGM by virtue of section 249N. So how do we convene this meeting? Convene means call for this meeting. Replaceable rules section 249C and section 249CA, a single director can call a general meeting. Section 249D, 5% votes can requisition director to convene a general meeting. So here, a member can requisition for the convening of a general meeting where they have 5% votes. Section 249D sub 5, director has 21 days to call the meeting that must be held within 2 months. Now, in your question, if you do find some numbers, some figures being thrown in, you need to think about it, because often than not, it relates to one of these sections. They talk about this shareholder has about 10%. Sometimes they give you the percentage. Sometimes they want you to work out the percentage. All right, so you are all accounting students. You should be able to work out the percentage without a calculator. But lawyers are not very good with numbers, so don't worry, they'll give you easy peasy numbers. All right, like 5%, 10%, not too bad. You can count that. Right, section 249E, if directors fail under section 249D, that means if the member has requested to convene a meeting and the director fails to convene the meeting, members with 50% of votes of who requested under section 249D can now convene the meeting. So 249D tells us members can request for a meeting, and if the directors fail to call for the meeting, then any members with 50% of votes who have requested under section 249D can now convene the meeting. And directors may be liable for the cost of the meeting. So here I ask the directors to convene the meeting. He doesn't convene the meeting. I then convene the meeting, and whatever costs that I incur due to the convening of the meeting, the directors will be liable to pay for it. All right, so if I have an annual general meal which is expensive, they pay for it. Too bad. All right? Meetings must be for a proper purpose, and in Humes and Unity APA, what happened was that they had a meeting where they wanted to remove some of the directors, and the resolution failed. When the resolution failed, again, the members tried to resurrect the same resolution. So they proposed the same resolution where they wanted to remove 8 out of the 10 directors. And this time, the directors refused to call for the meeting. Now, were the directors right in refusing to call for the meeting? That was the issue. The directors refused it based on the first time when the resolution was tabled in the meeting, it was rejected. Now you're bringing the same motion again for another resolution, and therefore I do not want to call for the meeting. So the member is very upset, goes to court, and the court says it doesn't matter whether it's a failed resolution. If the member wants to call on the same basis again, you should convene the meeting. All right? So that's what Humes and Unity APA. Directors should not have refused to call meeting even though the same resolution had recently been defeated. Then you look at NRMA and Parker. Directors correctly refused to call meetings since members cannot usurp directors' powers. Here they wanted to determine the way the votes would be taken, and to determine on how votes would be taken is a board of directors decision and nothing to do with members, and therefore their refusal to call for the meeting was rightly done. So in that case, it was okay. So you have two conflicting cases with different decisions. One, it says, although the motion has been defeated, it doesn't mean they can't bring it up again. In such a case, they still have the right, because Humes, what are they trying to do? Remove directors. Do members have the power to remove directors? Yes. So they can call for such a meeting, and you can't stop that. But in Parker, what they were trying to do was, they were trying to tell the directors how the votes should be taken. Now, to determine on how the votes should be taken, the powers lie with the directors, not with the members. So in such a case, that was not the right agenda or right resolution, because they do not have that right to pass such a resolution. So in that case, the directors rightfully rejected the calling of a meeting. Okay? Okay. Silence as usual means acceptance. Under section 249F, members with 5% votes can call meeting at their own expense. 249G, court has the power to order a meeting, right? And who decides on the agenda of the meeting? So I'm calling the meeting. Who decides on the agenda? The person who calls for the meeting can determine the agenda of the meeting, all right? Or directors. All right, what is notice? What is notice? I'm convening a meeting, but I don't tell you. Do you have notice of it? Can you come for the meeting? No. I'm having a meeting tonight, but I'll let you know just about an hour ago. Is that sufficient notice? No. All right? So that's the reason why we need to have requirements of notice. What is the requirement? Now, please note the word 21 days. What does that mean? If you are a company secretary, all this would matter, but I don't know how many of you are planning to be one. What does that mean, 21 days? I tell you, these are all contentious issues. Did it say business days? It said days. It will become calendar days. All right, when it's business days, they will mention business days. If it just says days, then it includes Saturday and Sunday. All right, so these type of things becomes very essential. Section 249H, it says 21 days notice. 249H sub 2 can be reduced if 90% of the members agree to a reduced number of days of notice. All right, which means almost all of them must agree to get a shorter notice period from 21 days. All right, and 249H 4 and 5, short notice is not allowed for appointment and removal of director or removal of auditor. So any other resolution you want to pass, you have shorter notice, you've got members agreeing to that, that's fine. But if you want to remove or appoint directors, or you want to remove an auditor, you cannot have short notice. It has to be full extent. Section 249HA, 28 days for listed companies, and this cannot be shortened. All right, for listed companies, you have too many members. You can't shorten the number of days of notice. 249L, notice must specify the place, date, and time of meeting, general nature of business, any resolutions to be passed, and proxy details. What are proxies? Maybe some of you are proxies to your friends because they can't make it for class. You make it for class, you take the notes, you pass it on to them. That's called proxy learning. All right? So sometimes the member can't come for the meeting. So what they do is they appoint proxies who will come on their behalf and also vote on their behalf. All right? So these are proxies. Notice must be clear and unambiguous. If content of notice is misleading, it may be restrained or resolution may be cancelled. Deverox Holdings, notice must be understandable by ordinary readers. So you don't use jargons. You don't confuse your members. You just tell them in simple language what is it that you're trying to approve. K and Croydon Tramways Company, it is a member's personal right to receive a truly informative notice. What is quorum? How many of you are members of some student body associations here? No one? Oh my God. What does student life entail? Come for lecture, go home. You all haven't attended any single meeting here. Okay. All right, I'll assume that's because you all are hard-working students who just concentrate, wham, wham, on company law, and that's it. Wear blinkers every time you come in. All right, now if you've attended a meeting, you need minimum number of people in there to continue the meeting. All right? And they must be there throughout the meeting, which means from the beginning right to the end. Now, if the quorum is 2, that means at the start of the meeting is 2, at the end of it is 2. Not halfway the person goes to toilet and never comes back. Then your quorum becomes 1. Now, that will be defective. Any resolutions passed there will become void. All right? So the quorum is the minimum number that should be present for a meeting. This is a replaceable rule. The quorum number can be changed by the company. If they are adopting the replaceable rule, they have a minimum of 2. But if they have their own constitution, they can say 5, 10, 15, whatever the quorum that they want. All right? And they must be present at all times. You can also see sections 249T, 2, 3, and 4. Can meeting be held in more than one place? Can you be in the Bahamas and still attend a meeting in Perth? Can? How? Skype, WhatsApp, God knows what else, every other technology. Well, Australian Corporations Act is very advanced. It was one of the most advanced Corporations Act in the world, actually. So they actually allowed technology to be used for attendance of meetings. So you do not need physical attendance. You can use technology. So you can use WhatsApp, you can use Skype, you can use whatever you want. All right, you can be present there. They can project you in. The next time when the technology improves, you can also be there like in an image. All right, a hologram being present there. You never know. So that's section 249S. Proxies and corporate representatives. Now, corporate representatives are corporations that hold shares. Now, corporations which hold shares, you cannot expect the company to walk, so they have to have a representative. These people will be known as corporate representatives. Replaceable rule, section 249X, it's only for proprietary company, and a member can appoint up to 2 proxies. And if you appoint a proxy, you have to ensure that you send the document to the company before within 48 hours before the meeting. So that means the company is then put to notice that proxies are representing you. A corporate representative can represent a corporate shareholder, Section 250D. What is the chairperson's role? He controls the conduct of the meeting or the forum, and Section 249U tells us, it's again a replaceable rule, tells us that the directors have the right to appoint a chairperson. Now, if a chairperson is appointed and that chairperson does not present himself or herself in the meeting, then the members in the meeting will have a right to appoint a chairperson amongst them. All right? But the right to appoint chairperson rests with the directors. And also the chair has a casting vote. If you have a deadlock, the chair can then vote in favor of whichever party. Okay. How many of you have understood what's gone on so far? If I conducted a meeting like this, I'll never get a resolution passed. Come on, guys, show of hand. Take a... Okay, I can accept that. Still doable. All right? Okay, I'm going to do this next time. So if you all don't answer, the next time you have private questions, I shall refuse to answer as well. Is that a deal? Not a deal. Okay. Voting is by show of hands unless poll is demanded. So normally we don't demand for a poll, but we'll just vote by show of hands. Section 250L, 5 members of 5% votes or chair can demand a poll. 249Y, proxy votes by poll. Constitution can allow proxy to vote by show of hands. 250D, company representative can vote by hands and poll. E, subject to Constitution, each member has 1 vote on show of hands or poll or whatever. Now, has this been examined before? I've never seen it in any of the assessment, but you never know. Okay? Now, what is an ordinary resolution? An ordinary resolution is a simple majority, 51% of the members approving. Now, when you read your Corporations Act, if the word resolution is used without the mention of special, that means it is an ordinary resolution. You won't see the word ordinary mentioned in the Act. It will only mention resolution. If it's mentioned as resolution, that means that's an ordinary resolution. Where it's mentioned as a special resolution, then obviously that is a special resolution. All right? So that's how you determine the type of resolution that needs to be passed. Here is 50% plus of votes cast by members present and voting. Actually, it's 51%. And special is 75% of votes cast by members present and voting. And Section 249L, details of special resolution must be stated in the notice of meeting. And 249A allows circulating resolution. What is circular resolution? Circular resolution is where no physical meeting has taken place, but a resolution, that means a letter or whatever, is written there, resolving all the resolution or stating all the resolution and supporting documents attached with that. And that circular resolution now will be passed to member, and after they've gone through the documents, they've seen all the supporting documents, if they agree to support the resolution, they will sign on the circular resolution. Normally, it's doable for a smaller company where you have not too many members. But if you have a public listed company, that will be completely impossible because you have got thousands of members. You can't get circular resolutions passed. It's going to be difficult. All right? Now, what happens if you have procedural irregularity? What if you passed a resolution, but then you did not have sufficient quorum? Now, that will be considered as an irregularity, and normally, if you pass any resolution which doesn't have a quorum, it would be void. However, under Section 1322, it states that if you have an irregularity that doesn't cause much problem or substantial injustice, then in that case, that irregularity can be ignored. All right? And this is in the case of Poliqua and Heaven Holdings Proprietary Limited. He alleged that there was not sufficient notice was served to him to attend the meeting. But in this case, he never attends meeting. Even if you gave him sufficient notice, he would still not attend. So it doesn't cause any substantial injustice to him. All right? Sometimes they will just try to find a way to actually say, or there's a breach or something is not regular. Okay? So what we looked at up to now is members meeting. Now we are moving on to directors meeting. So we looked at division of powers, we looked at members meeting. Now we are going into directors, before directors meeting, we are looking at company directors and other officers. Do we need a director? Do we need board of directors? No, we don't. The company will just run around by itself. Now, we do need directors. And where do we find the definition of a director? Now, please remember, any form of definition that you want to use, unless the specific definition is given in that particular section, always state Section 9. You won't go wrong. Section 9 is the definition section, and Section 9 will define most of the phrases or some words that's being used. It's always defined in Section 9. Now, a director is an officer of a company, and other officers that is in the company would be company secretary. Now, Corporations Act only requires 2 officers or provides for 2 officers. One is the director, the other is the company secretary. They are specifically provided for by the Corporations Act. All right, the other directors, chief financial officer, chief legal counsel, chief information officer, all these are creation of the company. It's not specifically required by the Corporations Act. All right, so if you want to become a company secretary, very important position. Okay? Section 9 defines officers as a person who participates in decision-making that affects the whole or substantial part of the company's business. In Morley and Essig, the chief financial officer, the joint company secretary, and the general counsel were held to be officers of James Hardie Industries Limited. We'll deal with this case when we get to directors' duties. This was about a disclosure of having sufficient funds to meet the claims of asbestos-affected employees. All right, so it dealt with that. Now, Section 9 defines directors as a person occupying and acting as a director by whatever name called. The first thing. So I appoint someone who acts as if he's a director, but I call him general manager. Now, is he a director? Under the definition, he will be considered a director. This is called de facto, by fact. By his actions, we can say that he is a director, by fact. De facto director. Next, de facto, and by whatever name called, and whether properly appointed or not. And sometimes a person has not been appointed on paper. You have not consented to be a director. You have not done anything to be formally appointed as a director. But you run the business as a director. You are again a de facto director. On another situation, you are not appointed as a director, you are nowhere in the building or anywhere in the company, but other directors in that company always follow your instruction. All right, always follow your instruction. Now, these directors are known as shadow directors. All right, shadow directors, they're not there. They don't make the shots, they don't call anything, but they actually direct the appointed directors to do the calls and the shots. This is a shadow director. Now, why do we need to know all these different types of directors? De facto directors, shadow directors. Those appointed directors, we know they are directly responsible to the company, and if they breach their duties, we can take an action against them. Can we take an action against de facto and shadow directors? Are they bound by the director's duties? Section 9 says they're still directors and they will still be bound by it. So we've caught them all, whether you're by fact director or you're a shadow director, it doesn't matter. If you acted in the capacity of a director, you would be bound by the duties. All right? Now, my advice is never give free services like, oh yeah, I'll advise you how to run the business and everything, because before you know it, you might be a de facto or a shadow director, and that's it. You'll be bound by the duties. Right, Section 201B tells us that the director must be a natural person. Natural person means like you and I. You cannot have a company being a director. It must be a natural person who is above 18 years old, 18 and above. If you were 17, you have to wait for a year to become a director. The next thing is you are not disqualified from being a director. How can you be disqualified? If you are a bankrupt, you'll be disqualified. If you were in a company before where you started a company and you collapsed the company, a few times you've done that, you'll be disqualified. You've been convicted before, you will be disqualified. Why we don't want people like that on the board? Sorry? They might not be reliable, they might not take good decisions, all right? And these type of people, you're just inviting unwanted trouble, so-called, all right? So these type of people will not be allowed to be directors. The minimum number of directors, Section 201A, tells us public company is 3 and proprietary company is 1. Now, for a public company, at least 2 must ordinarily reside in Australia, and for a proprietary company, that 1 director must ordinarily reside in Australia. Now, what is the role of a company director? It could be management or it could be supervisory. If you have a small company and you have got 3 directors, normally they will be involved in the management. But if you have a bigger company with bigger boards, like public listed companies, these board of directors do not run the day-to-day management of the company. They just supervise. They give the overall trajectory, the management trajectory, and they let the executive team control and run the business. All right, so they have a supervisory role. In ASIC and Healy, the role of directors was described as being placed at the apex of the structure of direction and management of a company. Now, what happened in this company is, how many of you are accounting students? As usual, nobody will put their hands up. Oh, my God, okay. Explain to me, what is current liability and non-current liability? Sorry? Within 1 year? And non-current? Okay. So if I have something, a loan which is current, but I declared it as non-current, what am I doing? Sorry? Not reporting properly. What is the impact? I could possibly inflate my profits. I could probably inflate my gearing. I can say I'm lowly geared when I'm actually highly geared. All right? Now, short-term liability is short-term loan. Is it current or non-current? Current. Very good. Even you know that. I know that. All right? So what happened in this case was that the directors actually signed off a document where they had made an announcement for $1.5 billion short-term loan as non-current. All right? And when they were called to task, they said, look, We are not experts in accounting. We do not know the difference between current, non-current, and all that. So we've just signed off the document. And this became a controversial case, actually. The courts then said, it doesn't matter whether you know accounting, you don't know. As a director, and because you hold a position at the apex, you have the responsibility to inquire. If you're not sure, you inquire. And if you've inquired and you've found out to your satisfaction that that has been correctly reported, then you sign it off. You can't just blindly sign off things and say it's not within my expertise. You agree? I think I agree with that decision. If you want to be paid highly, you want to hold that position, you have to also bear the risks. The greater the position, the greater the responsibility. All right? So that was what was held in ASIC and Healy, or what we call the Centros case. The board of directors make decisions at board meetings. The board can delegate their powers to a managing director. That's a replaceable rule under Section 198C, or committee of directors under Section 198D. Now, where a board appoints a managing director, the managing director will run the day-to-day management of the company. He will report it to the board, and where he needs further directions, he will go back to the board for further instructions. All right. Now, for company secretary, proprietary companies do not require a company secretary. However, a public company must have at least one company secretary, and this is found under Section 204A. Now, Section 204D, the directors will appoint the secretary. 204F, directors determine the terms and remuneration, meaning to say they will determine how much the company secretary will be paid and all that. So they'll enter into a contract which governs all these terms and conditions. Minimum age, again, is 18, and it has to be a natural person. It cannot be a company or something like that. It has to be a natural person. Now, company secretary has administrative tasks, and the case that I would refer to would be Panorama Development, Guildford Limited, and Fidelis Furnishing Fabrics Limited. Okay? Panorama Development, Guildford Limited, Fidelis Furnishing Fabrics Limited. Now, what happened in this case was that Mr. Baines was the company secretary of Fidelis, and he then decided to enter into a contract with Panorama's car renting business, and he rented luxury cars. He rented Rolls-Royce, Jaguars, all right? In the absence of the managing director, he entered into this contract and rented these cars. He said it is for the company, but he used it for his own personal use. One day he comes in a Jaguar, another day he comes in Rolls-Royce. Why not? All right? So the company found out, they prosecuted him, and off he went to jail. However, Panorama had some outstanding bills that needs to be paid. So when they asked Fidelis, look, you have to pay the amount outstanding, Fidelis said, look, Mr. Baines, as the company secretary, does not have the authority to enter into such a contract. So the question before the court was whether or not a company secretary had such authority. All right? In that case, Lord Dennings, Master of Rolls, as he was then, said, gone are the days when you actually consider a company secretary as a clerk. They're no longer clerks. They are actually chief administrative officers. Now, as a chief administrative officer, you can enter into contract to hire people. You can enter into a contract to hire cars. These are administrative tasks. And in this case, Mr. Bain, by virtue of his company secretary position, had actual implied authority. And therefore, Fidelis was required to pay Panorama. Your next week's lecture, which will be on iLecture because it's a public holiday, you will learn about authority. Now let's look at the types of directors that we have. We have got executive directors. These are full-time directors on the payroll. All right, they get paid. Non-executive directors are actually outside directors. Normally, we want them to be independent because they then bring independent advice to the company without any form of attachment. That means they don't have any other vested interest, and therefore decisions would be made on a merits basis. And in a public listed company, there is a requirement under the Australian Stock Exchange requirement which says majority of the board members in a public listed company has to be non-executive independent directors or independent non-executive directors. All right? And a chairperson will exercise control over board meetings and selects matters and documents to be brought to board's attention. We'll look at AWA and Daniels. It will be a very important case under directors' duties, in particular section 180 sub 1. So we'll look at that when we get to directors' duties. Now, who is a governing director? A governing director normally applies for a family-run business where they have incorporated a company, and these governing directors are normally the founders of this business. So they will have extra powers that may be provided under the Constitution where they can remove other directors and all that. So these are related to family-run business normally. Nominee directors. Now, nominee directors are actually representative of institutional investors. Institutional investors like your superannuation, they invest in a company. Obviously, they can't come, the company can't come, so they will appoint a director, and that director will look after the interests of that institution. So that's a nominee director. Alternate directors are where you are a director and you've got sick and you can't attend any meetings for the next 6 months. So you appoint a substitute. That substitute is known as an alternate director. All right, that's found under Replaceable Rule Section 201K. A de facto, I've already explained to you, who runs like a director, probably under a different label, or is not officially appointed but acts as if he is the director. That would be a director by fact, de facto. Shadow director is under whose instructions that the other directors decide. So they would be shadow directors. Let's look at appointment and removal of directors. Now, in relation to appointment, members can indirectly control this through the company's constitution, and appointment is found under Section 201G. This is a replaceable rule. They are appointed by members. And directors can fill casual vacancy, which means when there is a vacancy available in the board of directors, they can appoint a director, but that appointment must be approved in a general meeting by members. All right? And within a certain period of time, 2 months. Otherwise, that appointment will not be valid. Okay? Public company directors have to be individually appointed by separate members' resolution. Meaning to say, if you want to appoint more than one members in that one director in that meeting, you have to have separate resolution. Appointment of Mr. A as director, appointment of Mr. B as director, appointment of Mr. C. So it must be different resolutions or separate resolutions. Whereas a single director or shareholder proprietary company records and signs the appointment by themselves, obviously. Now, who can be appointed as director? Again, we've gone through this. A person, a natural person above the age of 18, and they must have signed the consent form to act as a director. Where will this consent form then go? I've signed the consent form to become a director. Then, where does it go? Which section relates to this? Section 117. What does it say? The requirement for registration of a company. So you have to attach all these forms with your Form 201, which you're submitting to ASIC to register a company. Now, 201B talks about disqualified and convicted persons or disqualified persons. Can a director resign? Of course he can resign. Section 203A. I think we have looked at this, so I'm not going to explain section 203 and 203D. C and D, are we okay? Okay, good. I can only see one head saying that, so you'll be representing everyone, proxy. All right? Public companies, company directors must be given 2 months' notice of meeting for removal, and the director has a right to give a written statement or to be heard in the meeting. So if you want to remove a director, you must give him the notice, and he has a right to represent himself and why he should not be removed, and he should be heard. All right? How can a director be disqualified? You can look at sections 206B. Automatic disqualification is for bankrupts and convicted persons. Court can disqualify a director, and ASIC may disqualify a person from acting as a director. So you can look at that, no worries. Proceedings of a board of directors meeting, replaceable rule 248. For the meeting of members, which section? We just did it. 249. Okay, 248 is directors, 249 is members. Just remember it that way. Right? 248C, a director may call a board of directors meeting. 248C, a single director proprietary company passes resolution by signing and recording it. Notice of meeting must be reasonable. It's not given number of days, but it must be reasonable period. Replaceable rule 248C. Replaceable rule 248F, quorum, 2 directors present throughout the meeting. Resolution passed by majority votes of directors entitled to vote. Now, minutes of a meeting is very, very important, both for the directors' meeting as well as members' meeting. This must be recorded in a minutes book, which means all decisions have been made and the minutes have been duly signed off. It must be kept in the book. And when auditors go in, they will actually look for the minutes because they want to see where did the authority to make a certain decision come from. And this would be evidence of such authority. All right, so that's the reason why minutes is very important. And again, for directors meeting, you can still use technology. You can be in the Bahamas enjoying yourself and still attend a meeting. Not a problem. All right, and 248A talks about circular resolution for board of directors meeting. Again, it's the same. You prepare a document and it circulates among the directors. And section 198D tells that the board can delegate these powers. So basically what we have looked at is we have looked at division of powers, which is what I will put an asterisk on, division of powers, and I will put an asterisk on members' meetings. These two areas needs a lot of concentration. Not to say the other areas do not require concentration, but in your 2 pages cheat sheet for the final exam, find a space to put this in there. All right? Okay, have a wonderful weekend. I will see you in a fortnight. All right, next week is a public holiday, and the week thereafter is our week free, so I'll see you after that. And good luck for the assessment. Yes.
I was in your 2 yesterday.